I bombed a fake court-martial and learned the one lesson that changed how I defend real cases. My first big court-martial lesson did not come from a real court-martial. It came from a fake one, a training exercise. A moot court-martial at the JAG School at Maxwell, Alabama. No real client, no real conviction, no real sentence on the line. And somehow, it still taught me one of the most important lessons of my career. Because I walked into that courtroom convinced I was about to impress everybody. And for most of the trial I did. My opening was sharp, my evidence handling was clean. My direct examinations were strong, my cross-examinations were aggressive. My objections were landing. I was absolutely killing it. But at the end, the judge gave me feedback I have never forgotten. She said, "Josh, I was so excited to see you. Your opening was fire, your evidence handling was amazing, your directs and crosses were wonderful. I was so excited to see your closing. And then you just petered out. You just petered out." That is burned into my brain. She's given so many feedbacks over the years that she probably does not remember mine. But that one sentence changed how I practice law. Because here's the deal. It taught me that if you're not focused on the end from the beginning, you are really not trying a case. You're just having good moments inside of one. And if you were the one accused in a court-martial, that lesson matters just as much to you as it does to your lawyer. Look, I thought I was crushing it until the one thing that really mattered exposed me as a fraud. Why doing a lot of things well still means you missed the point. Before I joined the military as a JAG, I had already been a practicing attorney. I had trial experience, I was comfortable in court, I loved being on my feet, I enjoyed the pressure, and I loved the fight. So when I got to my first moot court-martial, I was ready to shine. And honestly, in a lot of ways I did. I had a judge who was clearly smart, outspoken, funny, and completely at home in the courtroom. She had taught me in some other classes, and I was just ready to show her who I was. She was the kind of person you want to impress because you know she's actually a really good lawyer. So I got after it. I gave a short, crisp opening. I handled the evidence the way we had been taught. My directs were open-ended and storytell-driven. My crosses were controlled and purposeful. My objections were on point. I was walking around that courtroom like I owned it. Then I got to the closing argument. And frankly, it was not very good. Not because I didn't know the law, not because I wasn't capable, not because I suddenly forgot how to talk. It was bad because I had poured so much time and energy and attention into every other detail that I just treated the closing like it would take care of itself. And guess what? It did not. And that is when I learned something that most young trial lawyers learn the hard way. Being impressive throughout trial means nothing if you do not bring it home at the end. Start with the end is not just a slogan. It is a real trial strategy. How one bad closing argument changed the way I build every case. That feedback from my first moot court-martial changed how I practice law from that moment forward. Start with the end. That's the lesson. Start with the end. What does that actually mean? It means from the very beginning of the case, we are thinking about the closing argument. Not at the end, not the night before trial, not the weeks before trial, not after witnesses testify, from the very, very beginning. Every question you ask in an investigation, every document you review in discovery, every decision you make about theme, theory, witness order, evidence, you should always be asking, how does this help me at the end of trial when I stand up and explain to the fact finder why my side should win? Because the closing argument is where you pull everything together. That is where you bring it all home. That is where the facts stop being random pieces of information and start becoming a story with a destination. And if you have not been building toward that destination from day one, then what you really have is just a bunch of disconnected moments that might look good individually, but do not add up when it matters the most. That was my problem in that moot court-martial. I had a bunch of strong moments. I had a bunch of killer moments, but I had not started with the end. So when the time came for me to deliver the one thing that tied it all together, I petered out. This lesson is not just for lawyers. It's also for the accused too. Why defendants have to start with the end. This is where people miss the bigger point. Start with the end is not just about a lesson for lawyers. It is also a lesson for people accused of crimes. For the lawyer, the end is the closing argument, the verdict, the way the case gets framed when everything is on the line. For you, for the accused, the end is your life after this moment is over. And that means you have to think through multiple realities. What happens if you are convicted? What happens if you are acquitted? What happens if there are mixed findings? What happens if part of the case goes your way, but part of it does not? You cannot make smart strategic decisions if you refuse to look at all those possibilities. Because until you think seriously about what your life looks like at the end of each of those scenarios, you might not actually know what matters most to you. You may think your priority is one thing. Then when you sit down and really think about the end, you realize something else matters more. Maybe the administrative discharge matters most. Maybe it's the characterization of discharge. Maybe something else has a bigger impact on your future, your family, your benefits, your reputation, or your ability to rebuild your life after a court-martial. You do not figure out that priority by reacting emotionally in the middle of the process. You figure that out by starting with the end and working backwards. If you are facing a court-martial right now, this is exactly why you need a real strategy and not just someone who's a fighter. You need somebody who's not just reacting to the next hearing or the next witness or the next piece of evidence. You need somebody who's thinking about where this case is going, the whole picture, where this case is going to end, and how every decision you make throughout that process affects your life when it does. Real strategy starts when you get honest about the end, why clarity about outcomes changes every decision you make. One reason this lesson matters so much is that priorities can be deceptive. People often think they know what matters most to them, but they usually have not really tested those beliefs against the different ways a case could end. Once you start doing that, things get clearer. You stop thinking in vague terms like, I just want to win, and you start thinking in strategic terms like, what result matters most? What risk is acceptable? What consequences can I survive? What consequences could change everything in your life? What decisions right now give you the best chance of protecting what matters most later? Once you ask those questions, that is when you can actually work with your lawyer to build the right strategy for your specific case. Not somebody else's case, not some generic playbook, your case, your priorities, your future. And that's what start with the end really means. It means clarity first, strategy second, and action third. That is true in a courtroom and is true in life after one. So here's the lesson from one fake court-martial that turned into a very real career-defining moment for me. I walked into that moot court-martial feeling confident because I was doing so many things well. Strong opening, great witness work, clean objections, solid evidence handling. But I learned the hard way that confidence in the middle of trial is not enough if you have not built with the end in mind. That is why I now start with the end. For lawyers, that means building the case with the closing argument in mind from day one. For the accused, that means thinking through every realistic outcome and getting clear on what actually matters most in your life when this chapter is over. Because once you know what the end looks like, or what the multiple possibility ends look like, you can start making strategic decisions that actually move you to where you want to go. And that is the difference between just going through a court-martial and defending one well. Now that you understand why you have to start with the end, The next step is figuring out how to make strategic choices once you know what actually matters most to you. God bless. Have a great day.